welcome. We're happy to see you. We really are. We love having these webinars with you and really encourage you to be part of these webinars because our job is to educate you because we want everyone to be on the same page that we are. And as the laws are generated that apply to our clients, we want to share them with you. My name is Robert Galliano. I am one of 8 attorneys at Cope & Boger, and I love Cope & Boger and Cope & Boger because this is a law firm that is focusing on education and also fantastic support in everything that involves estate planning. My background is I have been an estate planner for many, many years. I am a certified specialist with the State Bar of California, and I have an advanced tax degree, obviously in taxes, which helps me to be able to discuss with you these elaborate laws that are being written as we speak. And today, I am going to be talking about a whole act that was really presented in 2 parts. I'm going to talk about how retirement plans are transferred at death, and I will definitely talk about what is the Secure Act, what is the purpose of the Secure Act. In other words, why was there a Secure Act promoted and implemented into law? I'm going to highlight the provisions of the Secure Act. The Secure Act is a very complicated set of laws, and what I want to do is to highlight the key provisions. And what I've done is I've selected these provisions with in mind as to how they affect you and I. Some of them are not applicable to us, and therefore I'm not going to be covering them, but I do want to cover the provisions that I think are interesting and appropriate to all of you. And I will talk about possible actions to minimize taxation. We at Cope & Boger are always looking and planning on how to minimize tax in every way that we can from a legal standpoint. And then people have already asked some questions on the Secure Act, and I will be answering those questions, and then how we can help you, absolutely help you with implementing some of these ideas and things. The most important thing that I really focus on at the beginning is the fact that the majority of you have spent years saving for retirement. You have done a fantastic job. I have met with a lot of you. I know the effort that goes into implementing and saving for retirement. And when you are ready to transfer your retirement nest egg to beneficiaries, what happens is that the majority of you transfer these wonderful retirement plans to beneficiaries without any planning whatsoever. And a lot of them are transferred, as you well know, by beneficiary designations. And that generally is when you open an account, let's say with the custodial of an IRA, you're given a form where you can identify who is the beneficiary of that specific account. And the 99% of the first, if you're married, the first beneficiary obviously is your spouse, but a lot of times you're leaving your retirement plan to non-spousal beneficiaries without any particular protection or any guidance or any tax planning whatsoever. An example of that would be, let's assume you have a $100,000 IRA and you leave it to your adult son, and you and I know what's going to happen with the $100,000, and your adult son will buy a Harley instead of going to Harvard. And that is common, simply. And I'll tell you why I think it happens is the fact that they did not work for it. You did, but they did not. So they're more than willing to accept the $100,000 and pay the tax, because what the heck? If I only have to pay tax on maybe 20% of it, I have the other 80% that I can do whatever I want. So transferring retirement plans without any particular guidance, I think, is not a very good idea. Again, what your beneficiaries will do is obviously, like I said before, they did not earn it. It was given to them. They're going to cash it out. They're going to pay the tax bill. A lot of the beneficiaries are not aware of the rules and choices that they may have. The beneficiary, or perhaps even your spouse, perhaps all they want to do is just get the money and spend it. And in addition to that, when they receive a large inheritance, I'll just use this example of a $100,000 IRA, once they have it in their hands, there's no protection from creditors, divorce, and so forth. And what if you're leaving the $100,000 to an elder beneficiary? Or what about if you leave an IRA to a disabled beneficiary who is not able to manage it? What if you leave the IRA to a beneficiary who's special needs? So when we leave an inheritance to a beneficiary, it is really important that we analyze the tax consequences, the management consequences, provide choices as to how they can protect it, because it's taken you a lifetime to save. And I don't think it's a good idea to just simply transfer a large inheritance to somebody without any type of planning whatsoever. And that is, I think, an important point that I want to make. Now, let's talk about the Secure Act. The Secure Act was really done in two parts. Way back in 2020, when the first Secure Act was passed in January 1 of 2020, quite frankly, we were all in shock because this Secure Act that was implemented a few years ago completely overturned the way we inherit IRAs, completely overturned the way retirement plans were handled. And when the Secure Act was passed in January 1 of 2020, there were so many questions that were unanswered. The regulations that were prepared and drafted had not been implemented. We were working under draft regulations. There were questions that we didn't understand. There were questions that were not being answered. So when the Secure Act first came out in 2020, it was really a scrambling to try to figure out how to implement all the provisions of the Secure Act. Then last year, right before Christmas, Secure Act 2.0 was passed by Congress. It had been in negotiations between the House and the Senate. Various types of proposals had been discussed, and finally, the Congress passed Secure Act 2.0. And today, I am going to explain the provisions of the original Secure Act and also what Secure Act 2 has done. And quite frankly, the Secure Act that was passed in 2020, which was a shocker, the Secure Act 2.0, I think, is full of provisions that benefits us. Because I think Congress is finally figuring out that a lot of Americans are not saving for retirement, and therefore they're trying to provide avenues and laws to assist Americans to save for retirement. So I'm going to have to give the passing of Secure Act 2.0 a plus, maybe not 5 stars, but maybe a 4.5 star, because it does have very good provisions. Now, the purpose of the original Secure Act. We know that the government is spending money right and left. That is not a secret. Every time you turn on CNN or Fox News, right, it's full of new legislation, trillions of dollars being spent. So if the government is spending all that money, how are they going to get the money back to pay it back? Where are they going to get the money from? Well, the answer is obvious. They're going to get it from you and I. And so what the Secure Act did, the original one, the purpose was to extract almost $16 billion in additional taxes from our retirement plans over the next 10 years, the government to cover the draconian spending that our government is doing right now. That doesn't sound fair to me, but that's exactly what happened. And so how are they going to recover then all this money in 10 years? What they've done is they started to attack retirement plans and IRAs. Today, I'm going to focus on IRAs. And yes, you have an IRA. You and I, when we take money out of an IRA, we're required to take out required minimum distributions, and we have to pay tax on the money that we withdraw. So we will be paying tax on our IRA during our lifetime. And now if you leave it to non-spousal beneficiaries, they will have to pay it after your death within 10 years. I'm going to say it again. The Secure Act that was passed in 2020 changed the rules so that someone who is inheriting an IRA that is not a spouse or does not qualify under other exceptions that I will cover, they will have to take out the money from that IRA within 10 years. Previously, the Secure Act, we were able to take out small amounts of money from an inherited IRA over a lifetime. An example of that would be prior to the Secure Act passage, if you left $100,000 to, let's say, an adult son who maybe was 50 years old, there's an IRS table that said that the 50-year-old maybe had another 40 years to live, and therefore he could have taken out the required minimum distributions from the inherited IRA over the next 40 years, taking out small amounts, allowing the account to grow tax deferred, taking out small amounts to be added to his income tax 1040, therefore minimizing the income tax that he would have to pay every year, and allowing the account to grow larger. The common terminology that we used to have for that was called it a stretch IRA. So the key provisions of the original Secure Act, I'll call it Secure Act 1 just for differentiating it from Secure Act 2.0. Okay, so when Secure Act 1 was passed, again, the requirement was, hey, if you inherit an IRA and you are not one of the following 5 beneficiaries that are on your screen, your spouse, a minor child of the account owner, or somebody who's a beneficiary that was less than 10 years younger than the account owner, or if you were not disabled or you were not chronically ill, if you did not meet one of these exceptions, then you were required to take out the required minimum distributions within 10 years. And during years 1 to 9, Secure Act 2.0 requires now the person who inherited the IRA to take out RMDs. When the Secure Act first passed in 2020, there was no requirement to take out required minimum distributions during the first 9 years. Secure Act 2 said, wait a minute, you have to take out RMDs within the first 9 years. But you have to make sure that everything is removed by the 10th year. So what is the effect of that? Look at the chart. Now, it's a busy chart, so let me kind of talk about it. The previous example, you left $100,000 to a 50-year-old. Previously, he could allow that account to grow for the next 40 years, tax deferred, compounding interest, taking out small amounts of money. And if you look at the chart, the green bars that you see is the growth of that particular account under the life expectancy rules that existed prior to Secure Act passing in 2020. Now, when you have to take out the money within 10 years, there is no 40 year, 50 years to let the account grow, and therefore you're stuck with an account that can only grow for 10 years. You have to gut it. And so the results of the Secure Act terminating the ability to stretch the benefits of the IRA has resulted in less growth and accelerated taxes. Again, if I leave $100,000 to an adult child, he has to take the money out within 10 years. So let's take an example. What if you leave the $100,000 to a child, again, I use the 50-year-old. He would probably be in his peak years of earning. He now has to take out $100,000 within 10 years. So let's assume that he says, I'm going to take out $10,000 a year. Therefore, by the 10th year, I've gutted the account as required. So he has to add $10,000 of additional income to his already income that he has, assuming that he is in his prime earning years. You can see the impact that it's going to have on him on taxes. So this is not a very good idea for inheriting IRAs, but it definitely was a good idea for the government because it's going to allow them then to collect the money on IRAs within 10 years. Now, a couple of provisions that I think are important for you to really focus on. And that is that everybody knew that the need to take out money that required minimum distributions, that requirement when you turn 70 and a half, you were required to take out the RMDs. We all knew that. We all live with that. But then the Secure Act, the original one that came in, what they did is they changed the beginning date to start taking withdrawals from age 70 and a half to 72 in 2022. So last year, then the required beginning date then for taking out required minimum distributions was for people who were 72 years of age. So Secure Act 2 increases when you have to take the RMDs out and increase the age to 73 in 2023. So this year, if you reach the age of 73, you'll be required to take out RMDs. And in 2033, the age to take out the required distributions will be 75. So what is the impact of this? If previous to the Secure Act, you had to start taking withdrawals from your IRA at 70 and a half, but now the age is 73 in 2023, it's allowing you almost 2.5 years of additional growth in your retirement account. Yes, additional 2.5 years of growth in your retirement account is compounded interest. It will allow then the account to grow. And when we reach the age of 75 in 2033, it's going to allow people then to have the account growing longer in a tax-deferred mode. That's the good part. Now, the bad part is that obviously the amounts of money that are going to be taken out are going to be larger, and they're the ones that then will impact then your tax return, your 1040, because the amounts that you're required to take out are going to be longer because hopefully the accounts are larger. Couple of other provisions. We know that if you are working, that you can still have an IRA, and there are numbers that are associated. Every year, there's a certain amount that you can contribute to an IRA. For example, the IRA catch-up contributions, $6,500 in 2023, and people over 50 can catch up an additional $1,000 per year, which now is going to be increased for inflation. So again, the government with Secure Act 2 is trying to promote our ability to have larger retirement accounts. And if you have an IRA that you haven't taken out all the proper contributions that are allowed by law, you will now be able to catch up with larger contributions. That's good news. Another one. There's been a lot of discussion about student loans. And you may not know what a 529 plan is. So I'll tell you, 529 plans are another way of investing for education. Generally, what parents or grandparents did or have done or are doing is that they are pretty much purchasing what is called the 529 plan. You put in money in there for a beneficiary's education, and then after a certain period of time, the money that's taken out for the benefit of education is tax-free. So 529 plans are a great way then to save and provide money for beneficiaries to get an education. So what the Secure Act 2 has done is they realize that people are in the workforce and they're working and have student loans. And therefore, now they are allowing then beneficiaries who have a 529 plan to take withdrawals penalty-free from the 529 plan to repay back student loans. That's a plus. Again, I want to hammer on this because this is really what the crux of the Secure Act is, and that is that if you are not one of the exempt people in the categories that I previously identified, spouse, they are not subject to the 10-year rule. If you're disabled, critically ill, if you're a minor, if you're less than 10 years younger than the owner of the IRA, those are people that are exempt from taking out money within 10 years. But if you're one of the persons that are not one of the 5 exceptions, you are required to take out the money within 10 years. Prior to Secure Act 2.0, if you left any money in that inherited IRA when the 10th year date came about, they were going to penalize you by 50% of the money that you did not take out. That changed under 2.0, Secure Act 2.0, from 50% to 25%. Let me explain that. Again, you leave $100,000 to Billy. He neglects to take out the money within 10 years. The 10th year rolls around. Billy has $100,000 still in that account. He forgot to take it out, didn't take it out, didn't have instructions, didn't work with anybody that instructed him what the rules were, and he will be penalized 25% of the $100,000 as a penalty. That is a whopping penalty. It's critical that anybody who's going to inherit IRAs understand what Secure Act 2.0 now is and does, and the consequences. A couple other takeaways. These are starting to get a little bit more convoluted, but I want you to realize that the Secure Act 2.0 added other benefits primarily to employer retirement plans. Previous to Secure Act 2.0, if you had a Roth in an employer retirement plan, you were forced to take out the RMDs from the Roth. Starting in 2024, that's not a requirement anymore. Why is that? Because you know that if you have a Roth IRA during your lifetime, you're not required to take any RMDs out. Now, therefore, what was happening, if there was a Roth in an employment retirement plan, they were being forced to take RMDs, so there it was not fair. So that's why this rule came into being. So now, if you have a Roth IRA during your lifetime, you know that you do not have to take out RMDs during your lifetime. That if you inherit a Roth IRA, you have to take out RMDs under the same 10-year rule. Now, you all know the difference between a regular IRA and a Roth, right? What's the difference? Your regular IRA, you take money out, you have to pay tax on it. A Roth IRA, the money comes out tax-free. The only requirement is that you have held the Roth account more than 5 years. And then later on, when you take money out from the Roth, it's going to come out tax-free. But questions that always come up. Does the Secure Act impact Roth IRAs? The answer is yes. If you inherit a Roth IRA, same rule applies. You have to take out RMDs and you have to take it out within 10 years. The difference is that the Roth is not going to pay tax on the money that came out. The other bullet on your screen talks about special needs trusts. If you have a child that is a special needs child, and if that child is going to inherit an IRA, that individual is in the exempt category. So he will be able to stretch out the benefits of the IRA over his lifetime because he would qualify under probably a disabled beneficiary. But you have to be careful because you have to have the right kind of trust for a special needs child. It has to be a special needs trust, and there's some rules that are preferably they're favorable for a special needs trust, and that is now a special needs trust can allow to have a charitable beneficiary in addition to the regular beneficiary that you normally would have. This was not permitted before. If you have a special needs child, it's really important that you talk to us as to how special needs trusts inherit IRAs. We're going to be doing a special webinar on this particular subject alone. And that topic is going to be how are IRAs to be distributed to a special needs trust. So be aware that we will be doing a webinar on that particular subject. Now, if you are required to take out money within 10 years, you now will not have the ability to stretch out that account over your lifetime like you did before. So if I want to establish an account so that I can have income over my lifetime, that inherit an IRA now under the Secure Act, I can't do that because I have to take everything out within 10 years. What if I have 50 more years of life to go? How do I do it? One way is transfer that IRA to a charitable trust. The transfer of the IRA to the charitable trust, because there's a charitable entity, there's no taxation. Any income generated within the charity from the IRA, there's no income taxation. And then the money can be distributed over the beneficiary's lifetime. They will have to pay income tax when they receive the income, but they will have an income stream that can be designed to be available over their lifetime or over a period of at least 20 years. The requirement of a charitable trust is that any remainder amount of money that's left in the trust would go to your favorite charity. But this is a technique that we still use to be able to take an IRA that you normally would have to gut within 10 years to allow that IRA then, through the use of a charitable trust, to be able to give you an income stream for life. Another obvious action to minimize taxes, choose beneficiaries that have lower tax brackets. If the adult child that's 50 years old in his peak earning years is in the 40% tax bracket, he's going to pay 40% on any money that he receives. So what if you have a beneficiary that maybe is in the 10% or 50% tax bracket? So by using some, I'll call it ingenious allocation of IRAs going to certain beneficiaries, you can lower the income taxation on your IRA, which is great. So what that means is that in your estate planning, then, if you have multiple beneficiaries, you can identify, oh, I will leave a tax time bomb IRA to a beneficiary who has lower tax brackets, in the lower tax brackets, and I will leave maybe another asset that's already been taxed to somebody who is in a larger tax bracket. It's just planning. Another one, which is fantastic, I like this one a lot. Did you know, and that if you receive $1 million life insurance policy, if you inherit $1 million life insurance policy, the distributions from life insurance at death are income tax free. If you receive an IRA and you take money out of the IRA, you're going to pay tax on the distributions. If you receive $1 million life insurance policy, you're receiving it tax free. So here is the trade-off. Use IRA money to buy a life insurance policy who will offset any amount of taxes due, and it will provide an income tax-free benefit to a beneficiary. It's basically swapping a taxable account for a tax-free account. The other one, which a lot of you have already done, and you know why you did it, and that is that distributions from a Roth IRA after you've held the account for 5 years are tax-free. You have to run calculations. You have to make sure that what you're doing is going to be economically sound for you. You don't simply decide to just convert your IRA to a Roth because there's tax consequences associated with that move. But there are certain ways to calculate the benefits. And for a lot of individuals, converting your IRA to a Roth IRA is definitely a good move. Some questions. Question number one on the left-hand side of your screen. Hey, I am already taking my RMD. How is the Secure Act going to affect me? It will not, because you're grandfathered in. Next question. Do these rules apply to Roth IRAs? Yes, they do. What happens, next question, what happens if I don't take the money out on time? Taking the money out, not taking the money out on time is going to cost a penalty. It used to be 50%, now it's down to 25%. But you do not want to get a 25% penalty for failure to take out the money within the 10 years. Next question, is trust planning still an option? Yes, it is. There's another category of trust that we don't talk about as often as we should, and that is trusts that are built to handle inherited IRAs. these type of trusts, IRA trusts, are built with special language that would allow, I'll call it, better tax planning when you leave an IRA to this type of trust. You will also be able to take advantage of some of the, I'll call it, planning discussions. It is a different trust than your regular revocable trust, and it is aimed at receiving IRA inheritances. That's the other subject of another webinar that we will be doing in the future. It's important that you listen to this particular webinar because there are a lot of you who have large IRAs, and it's critical that you understand what your other trust options are. And also, in our regular revocable living trusts that we have today, since the enactment of the Secure Act in 2020, we have changed and updated our current RLTs, revocable living trust, to include Secure Act language within our documents. I'll say it one more time. Since the enactment of the Secure Act in 2020, our current version of revocable trust, the Kopenbarger, have been updated to include Secure Act language within our documents. Next question. Talked about this a little bit earlier, is how do I protect my special needs child? This subject is important for parents of special needs children. You all know that in order to leave an inheritance to a special needs child, it has to be left in a special needs trust. With the advent of the laws that change IRA distributions under the Secure Act and the exempt category of a disabled child, allowing them to continue the stretch capabilities that existed prior to Secure Act, it's important that the trust for special needs children, if you're going to be leaving IRAs to that particular child, make sure that the language of the special needs child has been updated to incorporate the provisions of the Secure Act to allow the child to continue the deferral over their lifetime. Special handling because he is a protected, he is an eligible beneficiary under the Secure Act. The last question here really was, previous to the Secure Act 2 passing, we were working with rules and regulations that pretty much, quite frankly, they were not settled. We didn't really know what was going to happen and so forth. But the last question, are the rules and regulations final? The answer is under the Secure 2.0, now the regulations are final. So now we know what is happening. We have a better handle now as to what the Secure Act wants to do. And again, Secure Act 2.0 has implemented many, I think, provisions that are important in allowing Americans to be able to save in more for retirement. We talked about higher catch-up contributions on IRAs. We did not talk about qualified charitable distributions. I want to talk a little bit on what is a qualified charitable distribution. I did another webinar on this particular subject, but let me just kind of tell you what it is. It's really something that you should be aware of, and that is that let's assume that you are inclined to leave a stipend to your church. Let's assume, for argument's sake, that you want to leave $5,000 to your church. So what you do is generally people will then write a check from their savings account to the church, $5,000. But a qualified charitable distribution is another ruling that would allow you to take a required distribution that was mandated by your current IRA, let's just say $5,000, that if you receive it as income, you would pay income tax on it, that if you were to transfer that $5,000 from your IRA directly to the church as a stipend, that $5,000 would never be included in your tax return. You would have saved taxes. You still would have given the $5,000 to the church, a win-win situation. Again, there's another webinar that we did on this particular subject, and that's qualified charitable distributions. It's another area that needs to be explored with you, which allows you to minimize taxation, which is important. And pretty much the other elements of the Secure Act 2, I'm just going to tell you what the titles are, and I'm not going to get into them. And there are other changes that have occurred on annuities. Another one had to do with automatic portability distributions on retirement plans. Another one was the ability to take out emergency money from IRAs on emergency conditions, student loan debt discussions, 529 plan discussions. So Secure Act 2 really is I think, a positive update to the original Secure Act, because it's really rethinking retirement savings. It's really rethinking how you leave an inheritance from your hard-earned money from your retirement, IRAs, 401ks, and so forth. This is a very important subject, and I hope that if you have questions, you're going to write to me and that you will make an appointment. I want to remind you that we at Coker & Barger, the majority of you already know, we've been around since 1979. 8 full-time attorneys, 2 attorneys of counsel. We have CPAs. Half of us are certified specialists. Half of us have tax degrees. Combined experience, large years of combined experience. What does that really mean? The fact that all of us have been practicing for a long time, we have dealt with so many clients, we have dealt with so many examples, I'll call it case studies that we have learned over the years to handle. So we know how to handle the majority of cases that come before us. We're certified specialists in probate law, and again, we have advanced tax degrees, and we have a huge, huge staff. And we will do meetings with you in person or through Zoom or calls. We are here to help you. If you found this discussion helpful, if you have questions, we would like to hear from you. We're going to have a team available to assist you with any questions that you might have. On the screen, you have our telephone number, 800-244-8814. We can meet you through Zoom appointments. One other thing that I think is important for you to realize, and I talk to a lot of our clients, and sometimes they're not aware that our website has tons of webinars, tons of classes, tons of blogs that explain a lot of these complicated tax issues, a lot of planning ideas. We discuss all kinds of subjects trying to educate you, and they all are free on our website. So go to our website, cokerandbarger.com, and look for educational webinars on subjects that you might be of interest. When you meet with me, I would like very much to be able to see your existing estate plan. Even though you're a Coker & Barger client, we still would like for you to bring in your documentation. We will send you out a brand new confidential data questionnaire so that we can at least be updated as to what has happened since the last time that we met with you. and also bring with you all of the questions that you may have for me. And I will do my best to answer them. So with this, I'm going to conclude. I have spent close to 45 minutes with you. I want to thank you very, very much for being with me. I look forward to meeting with you. I look forward to answering all of your questions and I just thank you for being with me. And I want to thank you very much for your attendance. Thank you very much.